What is Doge? I keep asking myself that question, and with every thread I pull, things just unravel more. It's an advisory committee. No, it's a White House office. No, it's a department. No, not that one, the other one. Do you know what Doge is? Because I sure don't. But Doge sure seems to have a lot of power these days. Like a really, really suspicious amount of power. But it's cool, it's run by the richest person in the world. I'm sure he will understand the common man and will use his immense, unchecked power for good. Now, when millions of people voted for Donald Trump, they probably did not envision a situation where a few guys from Silicon Valley would storm through federal agencies tearing them down. Although, a few of them obviously did imagine that. But here we are. America is in the grip of a soft coup effectuated by a government agency named after a meme coin, led by the world's richest man who's so sensitive about his feelings, he pays others to play video games for him to make it look like he knows what he's doing. Yeah, it kind of sounds bad when you say it like that. But the Department of Government Efficiency, known as Doge, is chewing through the federal government, changing code, controlling trillions of dollars, accessing sensitive information about taxpayers, veterans, and federal workers, illegally freezing spending, closing agencies like the Consumer Financial Protection Bureau, and claiming to have shuttered the Department of Education, while also accusing groups like Lutheran Family Services and USAID of being criminals. Although President Musk's first 3 weeks in office have been chaotic, lawyers and judges have mobilized to stop Doge from breaking laws. So today let's talk about what Doge actually is, because I'm not convinced that anyone actually does, and all the lawsuits that are out there trying to stop it. Yes, Elon Musk and a small group of young men marched into multiple federal agencies with their personal computers, copied an untold amount of sensitive data onto private servers, threw the government into chaos, and then bragged about it on Twitter. Musk claims his raids on government computers is rapidly shutting down billions of dollars worth of illegal payments, but nobody elected Elon Musk as president, so how does he have the power to seize control of the IT systems of seemingly every major US agency? Well, because Donald Trump told him that he was a very special boy. Specifically that he was now a special government employee. So checkmate, that's the end of it. Totally legal, totally cool, nothing we can do here. Except that, of course, the law is clear that Musk's incursion into these agencies is outside the scope of special government employees, but that hasn't stopped Musk or Trump from treating the designation like it's a cheat code for unlimited and unchecked power, setting the stage for multiple monumental lawsuits. Of course, it would help if we could figure out what in the world Doge is in the first place. But let's start at the beginning. What makes a government employee special, and why are Trump and Musk convinced that this is a magic word that gives Elon the power to do whatever he wants? Well, in what is now one of the greatest twists of irony in modern legal history, the designation of special government employee was originally introduced into law to combat government corruption and rampant conflicts of interest. From time to time, the government needs to hire competent technical experts on a temporary basis to advise at the top level. And so this new designation was a means to do so while still holding these employees to a reasonable standard of ethics, accountability, and limit their scope. A special government employee, or SGE, is defined in 18 U.S.C. 202A as, quote, an officer or employee who is retained, designated, appointed, or employed by the government to perform temporary duties with or without compensation for not more than 130 days during any period of 365 consecutive days. Now, defining an SGE as principally an officer or employee of the government means that all SGEs are subject to certain ethical codes. And as outlined by an ethics briefing given to new SGEs by the Department of Commerce, SGEs are told, quote, you may not participate in any particular matter that will have a direct and predictable effect on your financial interests or those imputed to you unless you qualify for a regulatory exemption or receive a written waiver. Of course, Elon Musk is a walking conflict of interest. As the New York Times reported, his companies are, quote, increasingly facing regulatory battles and overlapping federal investigations from all corners of the government. So it makes perfect sense why, in the summer of 2024, Musk felt it timely to donate $277 million to the Trump campaign and use his celebrity to publicly go all in on the MAGA movement. And it seems that in return, Trump gave Musk the authority to raid financial records, networks, and private data of many federal agencies. Now, you would think that this alone means that Musk is violating conflict of interest restrictions, but some SGEs actually qualify for an exception to these ethics rules. Now, for the exception to the ethics rules to apply, the matters the SGE attends to must, quote, not have a special or distinct effect on the SGE or their non-federal employer beyond its impact as part of a broader class. The exception does not apply to financial interests such as stock ownership or other direct financial stake in the employer or prospective employer. Now, on a surface level, you can see why it's in the best interest of the government to allow for some exceptions to the conflict of interest rules, such as when Trump appointed Dr. Scott Atlas as a medical expert special government employee to advise on the COVID-19 pandemic. During the crisis, any direct government benefits distributed to all practicing doctors would have technically constituted a conflict of interest for Dr. Atlas, and so the exception would have protected him if he advised on such a course of action, because being a practicing doctor is part of a broader class. Now, the advice the special government employee Dr. Atlas actually gave President Trump was, don't worry about it, the whole thing will blow over, but generally you want your special government employees to be able to advise to the best of their expertise. And that's why Musk and Trump have repeatedly claimed that all Doge is doing is simply modernizing computer systems. And if that were true, Musk would likely be exempt from conflict of interest rules so long as he limits his activities to things like advising departments to upgrade to Windows 11, which, knowing his track record of giving terrible advice, is something Elon Musk would probably do. But we also know that that's not what Doge and Musk are doing here, especially when Musk called USAID an evil and criminal organization just months after its inspector general started investigating the millions of dollars of Starlink units it bought from Musk to assist Ukraine were being used effectively and appropriately, or when he accused FAA Administrator Michael Whitaker of destroying the human race after the FAA fined Musk $600,000 for gross violations of safety protocols at SpaceX, which delayed a launch for 6 months. You might recall that on Inauguration Day, Musk demanded that Whitaker resign his post, and Whitaker complied. Then he set his sights on the FAA, vowing to fix what was arguably one of the most complex yet reliable data systems ever created that millions of travelers rely on every day. Musk has since forced his way into several other agencies, including the GSA, the CDC, the Department of Labor, the National Oceanic and Atmospheric Association, and even gained complete access to the sensitive payment systems at the Department of Treasury that process over $5 trillion worth of government payments every year. And all the while, the White House says that Musk is not subject to any oversight. He will police his own conflicts of interest. And yet Musk's 6 companies are among the government's biggest contractors. The New York Times reported that 2 of Elon Musk's companies account for at least $15.4 billion in government contracts over the past decade. Now, Musk could get a conflict of interest waiver, but they can't be given retroactively, and the waivers have to be made public. Waiver requests for executive branch employees are covered by 18 U.S.C. 208b1. Under that provision, a waiver is available only if the person who appointed the employee says that the employee's financial interest in a particular matter, quote, is not so substantial as to be deemed likely to affect the integrity of the services which the government may expect from such officer or employee. SGEs must also receive a live ethics training before participating in deliberative meetings, and we're pretty sure that Musk took none of these steps, which means in no uncertain terms that he's not exempt from the conflict of interest rules. Except that at this point, there is no law, only enforcement, and if the executive branch says it doesn't want to enforce those rules, it's hard to force them to do it. The ethics training also says that SGEs are subject to criminal conflict of interest statutes, including 18 U.S.C. 201, which prohibits bribery, and 18 U.S.C. 219, which prohibits SGEs from serving as a foreign agent. But for any of this to matter, Trump's DOJ would have to investigate him, and U.S. Attorney Ed Martin already made the DOJ's position on Trump and Doge abundantly clear. When people started identifying Musk's henchmen, the young guys who now have access to the sensitive government data, Musk said disclosing their identities was a criminal act, and Martin backed Musk up in less than an hour, sending a letter warning Americans that they could be prosecuted for interfering with Doge employees or identifying them. Now, FYI, Martin is wrong. Musk, as a special government employee, ultimately works for the American people, and you have a right to know what he and Doge are doing with your data. Now, obviously, if you're going to try to fire half of the federal workforce under dubious legal authority, you'll want a good lawyer. But if you want a great lawyer, my law firm, the Eagle Team, can help. If you've gotten in a car crash, suffered a data breach because Doge leaked all of your data, or are dealing with a workers' comp or social security issue, maybe because you got fired by Doge, we can represent you or help find you the right attorney. It's so important to talk to a lawyer right away so you can maximize your recovery. And by the way, we don't get paid unless you do, so there's nothing up front. So just click on the link in the description or call the phone number on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle Team. Especially now. Now, what Doge is on paper and what it and Musk are doing in practice are 2 completely different things. Trump established Doge as an advisory group before he was inaugurated. And when he returned to the White House, he created it by issuing an executive order renaming the U.S. Digital Service as the U.S. Doge Service, and reestablishing the office under the executive office of the president. Now, spoiler, this probably is not legal. Trump claims that Doge is a temporary organization under 5 U.S.C. 3161, and his executive order mandates that each federal agency create a Doge team of at least 4 employees in consultation with the U.S. Doge Service, God, I hate that name, to implement this agenda. Now, according to the order, Doge will finish up its work by July 4th, 2026. Now, in his executive order, Trump says that the mandate for Doge is to modernize software, quote, the USDS administrator shall commence a software modernization initiative to improve the quality and efficiency of government-wide software, network infrastructure, and information technology systems. The USDS administrator shall work with agency heads to promote interoperability between agency networks and systems, ensure data integrity, and facilitate responsible data collection and synchronization. But the executive order does not give Doge the authority to override agency heads. It states, quote, nothing in this order shall be construed to impair or otherwise affect the authority granted by law to an executive department or agency, or the head thereof, or the functions of the director of the Office of Management and Budget relating to budgetary, administrative, or legislative proposals. However, in practice, Doge far exceeds the typical scope of a temporary organization's mandate. And perhaps most importantly, only Congress has the authority to create or dismantle federal agencies and control spending. But Musk asserts that Doge has a much broader mandate granted to him by Trump, even though it's not within the powers of the executive branch to do so. He claims that Doge has the right to offer buyouts to employees, cut $4 billion from the budget each day, investigate fraud, close down federal buildings, and freeze spending. These are not things that temporary organizations do, let alone one tasked exclusively to modernize software. In fact, I'd argue that these aren't things the executive branch can do at all. It's exclusively the purview of Congress. But at least temporarily, for all intents and purposes, it seems that the world's richest man is illegally running a department that oversees the entire government. And that's the main issue with Elon Musk. Even if his actions fall well outside of what the law permits a special government employee to do, he can only be stopped if someone in a position of power stops him. And that can really only be done by Donald Trump himself, or possibly maybe the courts, because hopefully they follow the court orders. But at least the lawyers aren't taking this lying down. In fact, our friends at the National Security Counselors, including Kel McClanahan, have filed a lawsuit in Washington, D.C. that strikes at the heart of Doge. The plaintiffs allege that the creation of Doge violates the Federal Advisory Committee Act, or Faca. The Faca bars the president from delegating decision-making authority to private citizens like Musk without public transparency, and prevents advisory committees from being used to exert undue private sector influence on government decisions. Advisory committees must hold public meetings, keep detailed records, and have a clear purpose with government oversight. And this raises all kinds of questions about whether Musk's status as a special government employee grants him a universal get-out-of-jail-free card, or whether Doge can get away with everything so long as it wears a USDS skin suit. So to sort through all of Doge's, Musk's, and Trump's legal gaslighting, we went straight to the source of the lawsuit, Kel McClanahan. Thanks for joining, Kel. Can you walk me through your case? What are you claiming?
The Department of Government Efficiency, the Doge that Elon Musk has set up, it is set up as an advisory committee. And the way that those work, those have to follow certain rules. The Federal Advisory Committee Act is a law that is designed to make sure that random people from outside don't come and start being basically a shadow government, making the choices for the government that the government then follows. So the rules are that they have to be transparent, they have to have open meetings, they have to have records that can be subject to the Freedom of Information Act, and stuff like that. Most importantly for this case, they also have to be balanced. And that doesn't mean balanced as in Democrats versus Republicans. It means balanced in viewpoints. In this particular case, you have Doge, which is supposed to be going through, at least from its earliest mentions before the inauguration, going through and deciding what is best for the American government, including getting rid of a lot of workers. And yet, they had no workers. They had nobody from the federal government on it, and that is not fairly balanced.
And what do you expect the counter argument to be?
Well, on Inauguration Day, they thought they found one weird trick. Donald Trump issued this executive order that basically said, I'm creating the United States Doge Service. And this is an office that's going to be within the executive office of the president. It's going to be wearing the skin, Buffalo Bill style, of the U.S. Digital Service that was an OMB office. And therefore, it's not an advisory committee. It's an EOP office. The problem is that when they did that, they implied that everyone who was in Doge, Elon Musk and all of his cronies that were out there talking about everything they were going to do to get rid of the workers, would be in the U.S. Doge service. But they didn't actually do that. And they didn't actually say that. And so right now, their argument is, as you ask, going to be that, well, it's not an advisory committee anymore because it's an office in the White House. And I'm not sure that's going to carry the day, given that Elon Musk is out there doing things in Doge's name when he's not even confirmed to be part of the USDS.
Well, here's what I've been wondering this whole time. What even is Doge?
That's a good question. The Department of Government Efficiency is not a department, and apparently it's not even focused on government efficiency. As one person said, it's an idea. But sometimes it's not an idea. Sometimes it's an office in the White House. Sometimes it's a loose consortium of billionaires. No one can really pin down what Doge is. The best we have to go on is that shortly after Trump was elected, he said, I'm nominating Elon Musk to run Doge. First of all, you know that Trump didn't come up with that name of Elon Musk's famous meme coin on his own for the department. That was a Muskism. They said Doge is going to go through and make the government more efficient, and that's what it's the department of. Then they started running around, pretending to be a real thing, hoping they'd be a real boy soon. And agencies didn't know what to do with it. They didn't know what to do with these people who said, I'm Doge and I'm coming to ask questions. Like, that's nice. Biden's still president. You don't have any power here. And then the election happened. And for about 6 hours, Doge was unabashedly an advisory committee because the executive order had not been issued yet. And then this U.S. Doge service was created. What Doge is, it changes on a day-to-day basis. Even the Republicans can't decide what story they want to get behind for what Doge is.
What about the pilfering of data? Did Musk have legal authority to enter these agencies and get access to sensitive information stored on their servers?
Well, that's a two-part question. The answer to can he get into the agencies is sure. I mean, if he's given permission from the White House to go to an agency, he can go to an agency. If I'm given permission by the White House to go to an agency, I can go to an agency. If I'm given permission to talk to people at the agency and they're told to listen to me, I can do that. Getting access to the servers is a different question. There are these routine uses, and that's a term used in the law. And the routine uses are things that the agency is allowed to do with PII in one of these systems, personally identifiable information in one of these systems, and where they can give it, who they can give it to, what they can do with it, and for what purposes they can do whatever with it. The reason for a routine use is that if you disseminate PII without a routine use, you are violating the Privacy Act. Routine uses will be things like for payroll data, well, your bank account information and your social security number and your name are used for HR purposes, for hiring and firing and promotions, for paying you, for making sure you get your money. Almost no routine uses say, and be given to the White House for reasons. And I can pretty much guarantee that no routine use says being given to advisory committee members, or even worse, random billionaires with a White House hall pass who just wander in and ask for it.
Did Trump moot your case by naming Musk as a special government employee?
Absolutely not. The most that Trump did when he named Musk a special government employee was say that he was now eligible to work for the U.S. Doge service. He didn't say he worked for the U.S. Doge service. In fact, the fact that Musk is a special government employee came out when people were asking, is Musk the U.S. Doge administrator who, by executive order, is the head of the U.S. Doge service? And the answer from the White House is, he's a special government employee. Well, that's nice. I'm glad he's a very special boy, but he's still not confirmed to be the U.S. Doge administrator, which means he is at best a random guy and at worst, for the law, a member of an unofficial illegal advisory committee, which is exactly what we alleged all along.
Now, Trump's executive order and his public statements talk about Doge simply modernizing computer systems, but that's obviously not what they're doing. How do you square that circle?
So you can, but it doesn't help. If they say that Elon Musk is the U.S. Doge administrator, and they say that everyone working with Doge is part of the U.S. Doge service, or one of these little away teams that go out to every agency and do fancy stuff for the week, then that doesn't help matters, because the mandate of the U.S. Doge service is to modernize government IT. And so if their job is to modernize government IT, and they're out there firing people and cutting off funding to grants and cutting off Medicare payments and messing with the Treasury system, they're not modernizing government IT. And so they're exceeding their mandate, which opens up a whole new bucket of random legal issues that they'll have to deal with. And I think that's why they're living in the ambiguity. They're milking the ambiguity to say, if you say they're an advisory committee, no, we're not, we're a service. And if you say, you say, well, then if you're a service, we're this, they say, oh, no, we're just sort of unofficially doing things. And so either way, they're screwed legally.
Now, you just said that they're legally screwed. Does that rely on the DOJ going after them?
Most of the laws that they're violating are not criminal penalties. They're not criminal cases that have to be prosecuted by the DOJ. In fact, the reason most of these laws are written this way is to allow you, me, random guy on the street, to litigate against the federal government and say, you are doing something wrong. Your Honor, please make them stop doing this wrong thing. And that is because they all waive sovereign immunity. Sovereign immunity says that you cannot sue the government without the government's permission. And that permission normally comes in the form of a law, a statute that says this creates a private right of action. The Administrative Procedure Act, which we're suing under in both the Federal Advisory Committee Act case and the E-Government Act case that I'm also bringing against OPM, is one such law that says this creates a private right of action. You may sue the government when it is breaking another law. The judge is saying, okay, let's give them the benefit of the doubt and say that special employees are treated like employees for the purposes of the Privacy Act. They still have to be employees of the Treasury Department and not of somewhere else. And so that's a distinction that's very defensible.
So what happens next with the case?
Well, right now we're still trying to figure out the scope of Doge. Is it a White House office? Is it a random bunch of billionaires and tech lords? We don't know. And every story that comes out in the media every day tells us something different. And until we get some clarity on that, we can't tell which way the case will go. Our website is nationalsecuritylaw.org. We are a 501c3 nonprofit. We've been around for about 15 or 16 years. I lose count in my old age and dotage. And we are out there doing what we do. We're doing cases like this, but we're also representing employees. We're also representing people who want to tell their story, write books, people who have lost security clearances, everything you can really think of in the field of national security law or sort of the information and privacy law type of work that isn't criminal. We're not criminal lawyers. That's what other people do. Right now, we just go and we help you fight the government when the government is the bad guy.
Kel, thanks so much for talking with us today. Kel's firm, National Security Counselors, has worked with LegalEagle several times, including most recently filing suit over Jack Smith's Trump prosecution documents. The National Security Counselors work closely with all sorts of government whistleblowers, and they have their hands full right now. So you can directly support Kel's work by clicking on the link in the description. Now, Kel's lawsuit argues that Doge is an illegal advisory committee, but we don't know if the courts are going to see it that way, because the honest truth is that nobody knows exactly what Doge is, least of all the people that created it seems. Doge was created by executive order of Donald Trump, and now the rest of the federal government is playing catch-up, while Elon Musk is moving fast and breaking laws. And that's what led the state of New Mexico, joined by 13 other states, to sue Elon Musk on February 13th. In the case of New Mexico versus Musk, the 14 states alleged that President Trump unlawfully delegated extensive authority to Elon Musk without proper legal authorization from Congress and without meaningful supervision. The plaintiffs argued that this concentration of power violates the Appointments Clause of the U.S. Constitution. Article 2, Section 2, Clause 2 requires that, quote, ambassadors, other public ministers, and consuls, judges of the Supreme Court, and all other officers of the United States be appointed by the president with the consent of the Senate. However, the president can also appoint inferior positions without Senate confirmation. Generally, positions that fall into this inferior officer category, which don't need Senate confirmation, are people like administrative staff, assistant U.S. attorneys, the White House chief of staff, and advisors. So generally, the White House has been arguing that Elon Musk is doing nothing more than the type of consultation you'd expect from an inferior office and doesn't have the authority himself. So how did the plaintiffs reach the conclusion that Musk violated the Appointments Clause? Well, it all starts with their allegations about what Doge really is. The states argued that Trump's executive order actually created multiple entities, not just one. In the January 20th executive order that set all this in motion, Trump renamed a pre-existing entity, the United States Digital Service, into the newly minted United States Doge Service, and his executive order goes on to give the Doge Service a different mission and structure than what the U.S. Digital Service did for its entire existence. This is the skin suit Doge that Kel and I talked about just a second ago. But the executive order also created another entity, the U.S. Doge Service Temporary Organization. The executive order says that a Doge administrator will head up the temporary organization, where they will, quote, implement a software modernization initiative to improve the efficiency of federal software and information technology services and promote interoperability among agency networks and systems. And there are 3, possibly 4 different organizations at issue here. The first is the old U.S. Digital Service. Has Doge, as in the Frankenstein entity headed up by Elon Musk, really replaced the newly minted United States Doge Service? We don't really know, and it would be a mistake to concede this. Remember, the United States Digital Service was a separate agency dedicated to making government technology work better, and the old website is still live and mostly unchanged. On that site, you can see the type of activity that the US Digital Service used to do and might still be doing, such as improving the SSA.gov website and making sure, quote, it is useful and usable and simplifying veteran-facing services on va.gov. And those were good and worthwhile activities for the government to pursue. But those are absolutely not the activities that Musk's Doge is now performing. And as far as we know, the digital service employees aren't involved with Musk's Doge at all. What happened to these employees? Are they trapped in some kind of weird simulation like the people who work in Severance? I don't know. But the government now says that Musk isn't the administrator of the US Digital Service and that he's also not an employee. Meanwhile, the USDS engineering director has resigned, and last Friday night, Doge let 50 USDS employees go. Wired, which is doing some really top-notch reporting these days, reports, quote, Amy Gleason, a former Trump administration USDS official, and Kendall Lindemann, formerly of McKinsey & Company, a management consulting firm, explained to the remaining staff members that Doge would become increasingly more hands-on within the organization over the coming weeks and months. Of course, Gleason and Lindemann refuse to say what their job titles are. Yes, here we go again. Are they special government employees, advisors, consultants? Your guess is as good as mine. They also refuse to disclose the names of the USDS administrator or the deputy administrator. The second entity is Musk's Doge, which doesn't have anything to do with creating a better digital experience. Know that the second entity, the thing we're calling Doge, seems to have authority over the Doge teams, which Trump created in his second executive order. That executive order creates Doge teams at every federal agency, which are responsible for hiring and firing. And again, that seems to have little to do with the first entity. If the Doge teams are obeying Musk, who the government insists is part of neither the USDS nor the USDS temporary organization, then they've got to be serving the unlawful advisory committee Doge that's been lurking in the background and pulling the strings this whole time with literally no legal standing to do anything. And the third is the temporary organization. The executive order establishing this is strangely written. It says, quote, establishment of a temporary organization, there shall be a USDS administrator established in the executive office of the president who shall report to the White House chief of staff. And we don't think the administrator directly runs the temporary organization if we go by what's on paper. The executive order states that the temporary organization is, quote, further established within USDS, and the temporary organization shall be headed by the USDS administrator and shall be dedicated to advancing the president's 18-month Doge agenda. So someone at USDS runs the temporary organization, but we don't know who. We only know it's not Musk. At least they say it's not Musk. So therefore, by its terms, we seem to have two Doges, the actual Doge, which again is just Elon Musk and friends wearing a skin suit carved out of the corpse of the US Digital Services, but we also now have the US Doge Service Temporary Organization, which is ordered to be run by a Doge administrator, and it has a baked-in expiration date. But then, as the lawsuit alleges, the executive order also created, quote, the Doge teams, which are intended to be embedded in every federal agency and will typically consist of a team lead, one engineer, one human resources specialist, and one attorney. The Doge teams were to be created through the consultation between the relevant agency head and the Doge administrator. Now, these Doge teams effectively give Doge, which is an executive agency, tentacles into every agency across the government, which, I shouldn't have to remind you, is not how honest and efficient government works. And so, which Doge do the Doge teams serve, you might ask? Skinsuit Doge or Doge with an expiration date? Well, who's to say? The executive order isn't clear, and so Elon Musk and his mostly unnamed team members are operating in a manner that's incongruous with the Trump executive orders, and they continue to exercise power that seemingly was never afforded to them by Congress or through the Appointments Clause. Though the counterargument that may be too cute by half is that Elon Musk technically doesn't have any power. He's simply making recommendations to the president, and the president then pulls the trigger. And thus Musk and his team have no real power and would not violate the Appointments Clause. And even though the Doge temporary organization expires on July 4th, 2026, the complaint points out that, quote, on its face, the executive order exempts the Doge service, Doge administrator, and Doge teams from the July 4th, 2026 sunset provision. So what we're then left with is an eternal Doge department, since whatever is left of the Doge expiration date after July 4th can just roll up into the skinsuit Doge. And arguably, this is why the Appointments Clause exists. The framers of the Constitution had the foresight to understand that a single department of government, unchecked in its power, could eventually become the supreme ruler of the entire government. So on February 17th, in response to the state's lawsuits, the White House submitted a declaration by Joshua Fisher, the director of the Office of Administration, stating that, quote, the U.S. Doge Service is a component of the Executive Office of the President. The U.S. Doge Temporary Service is within the Doge Service. Both are separate from the White House. Now, crucially, and I would say unpersuasively, the declaration clarifies that Elon Musk is not the Doge administrator. Musk is employed by the White House office as a senior advisor to the president, a position that gives him no greater authority than any other White House advisor. The declaration asserts that Musk is also a special government employee. Now, if you feel confused, that's probably the intent here. The White House is claiming that the US Doge with an expiration date is actually a subdepartment of the skin suit Doge, and both are separate from the White House office, which is where Musk works as an advisor to the president. So if you follow that logic, the White House would have you believe that Elon Musk is not formally associated with Doge at all, nor appointed to any position of sufficient power to warrant Senate confirmation. And this idea is further reinforced when Fisher goes on to claim, quote, Mr. Musk has no actual or formal authority to make government decisions himself. Mr. Musk can only advise the president and communicate the president's directives. Stephen Miller followed up on this inane theory of Musk's power, claiming to CNN that Musk and Doge had nothing to do with firing employees of the National Nuclear Security Administration.
So then who is it making those decisions of which federal employees are terminated?
Well, in that case, the Secretary of Energy would be the one. So what you're describing with the cuts in the Department of Energy, those are directed by the Senate-confirmed Secretary of Energy.
But guess what, everyone? Just 2 days after Fisher's declaration, Donald Trump admitted that he had appointed Musk.
Put a man named Elon Musk in charge. Thank you, Elon, for doing it.
Yeah, anyone who was following this at all would agree, yes, he absolutely did. And despite Stephen Miller's insistence that Musk is no different from Trump's other advisors, Trump has other ideas. He said explicitly, I put a man named Elon Musk in charge. And being in charge is different from he makes recommendations and maybe I follow them, maybe I don't. Unfortunately, Anna, I don't have an answer for you. Because over the last 6 weeks, Musk has been everywhere claiming that he exercises near total control over the government. And once Doge gets access to an agency, Musk claims to have control over who gets fired and who gets paid, and in some instances, what agencies get shut down altogether, like the Consumer Financial Protection Bureau. And he seems to have a lot of control over even who gets criminally investigated. And this is echoed in the New Mexico versus Musk case, where the plaintiffs say that Musk's access, quote, is seemingly limitless and dependent upon Mr. Musk's discretion. They then go on to argue that Musk, quote, in many cases has exceeded the lawful authority of even a principal officer or of the president himself. Trump stated that Mr. Musk will pave the way for my administration to dismantle government bureaucracy / excess regulations, cut wasteful expenditures, and restructure federal agencies. It is doubtful that any one officer of the executive branch has the authority to make such cuts, let alone an unconfirmed government employee. And yeah, I don't want to sound like a broken record here, but this isn't just one weird trick that they're finally pulling that no one else thought to do. You can't withhold funding, rearrange agencies, and mess with the congressionally approved laws without violating the Appropriations Clause, the Take Care Clause, and the Impoundment Control Act. And Trump was even confronted about Musk's sweeping power. 10 days before the lawsuit was filed, reporters asked why Doge needed access to sensitive Treasury Department information, and this was his response.
Well, it doesn't, but they get it very easily. I mean, we don't have very good security in our country, and they get it very easily.
And on the following day, President Trump's statements illustrate that no one stands between Musk and Trump in the executive chain of command. Quote, I've instructed him to go check out education, to check out the Pentagon. So now the government insists that Elon Musk is not the Doge administrator, which presumably means that role is vacant, I guess. And if the role has always been vacant, it could mean that Doge with an expiration date still has yet to become active. Now, the states were hoping that the courts would grant a temporary restraining order against Musk and Doge, but on February 18th, Judge Chutkan denied their motion. She found that the states did not carry their burden, showing that they will suffer imminent and irreparable harm. The court said, quote, plaintiffs' declarations are replete with attestations that if Musk and Doge defendants cancel, pause, or significantly reduce federal funding or eliminate federal state contracts, plaintiff states will suffer extreme financial and programmatic harm. However, whether these harms will come to pass remain uncertain. When litigants have identified specific individuals or programs imminently targeted by defendants, courts have issued appropriately tailored TROs. And Judge Chutkan cited the AIDS Vaccine Advocacy Coalition versus Department of State and Doctors for America versus OPM. In both those cases, Doge's sudden interventions caused concrete harm to specific programs. In contrast, Judge Chutkan said that the states can only point to media reports about what Doge is up to, but quote, these reports cannot substitute for specific facts in an affidavit or a verified complaint that clearly show that imminent and irreparable harm, loss, or damage will result. And even if the court could appropriately consider the news reports in conjunction with defendants' vague representation, many employees were terminated. But as we've talked about many times, a TRO is a very extreme form of relief that's used for emergencies. And although the judge denied the motion for a TRO, she didn't rule on the merits of plaintiff's appropriations clause arguments. And she signaled that she might be open to a preliminary injunction after more briefing. So are the Doges plural legal? Heck if I know. I don't even know what they are. Now, Doge is arguably one of the greatest threats to data privacy that the world has ever seen, especially because so little is known about what data they actually have access to. And even if you're not a government employee, the data that the government has about you is now in serious risk of being compromised. And all it takes is one hack of any computer connected to Doge for your personal and private information to then be endlessly copied and sold to data brokers, who then copy and sell it to anyone in the world for pennies on the dollar, leaving you drowning in scam calls, spam emails, and junk mail. But luckily there are people out there who can help, and that's why we recommend signing up with today's sponsor, Incogni. You can use my link in the description for an exclusive 60% off discount. Because Incogni removes your personal data from online data brokers by reaching out directly and forcing them to take your personal info down. If these data brokers resist, Incogni will take care of that too, because Incogni fights back. These data brokers are the reason why in the US you can search your name and find a bunch of websites that will give anyone your home address, phone number, and extensive history. It's shocking just how easy it is to find all this information. It also might be why you're getting so many spam calls lately, or even how someone might steal your identity. But Incogni is a great way to take back control of your data, increase your online privacy, and cut down on those annoying scam calls and emails that used to flood my voicemail and inbox. I've been using Incogni for years. In that time, you can see I've been on hundreds of lists, some of which had a high sensitivity score, meaning the broker had tons of data on me. Luckily, Incogni has completed hundreds of takedowns for me over the years and is processing dozens of others. If I were to try this myself, it would take hundreds of hours. So thank you, Incogni, for saving me hundreds of hours and adding me to over 40 suppression lists. And Incogni will continue to conduct ongoing removals because even if the data broker removes your data once, they can collect it again. And Incogni makes sure that your personal information stays off the market for good. So if online privacy is important to you, give Incogni a try. So if you click on the link that's on screen or down below, you can try Incogni risk-free for 30 days and get a full refund if you're not into it. But if you do decide to keep it, you still get the exclusive 60% off discount so long as you use my link or the code LegalEagle, all one word, at checkout. So click on the link down below for an exclusive discount from Incogni. And after that, click on this link over here for more LegalEagle, or I'll see you in court.